Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who geek out on the channel all the time, you know that oftentimes we will go through petitions, memorandums, briefs that have been filed by either the federal government or various state governments in support of pieces of civilian disarmament legislation. And it always amazes us just how intellectually dishonest and sometimes how downright stupid the government can be, and they actually put it in writing. We don't do what we're about to do today as often, which is actually focus on all the stupid crap they say when they're giving oral arguments. And today is a prime example of, well, they'll say just about anything to support civilian disarmament. Don't believe me? We're going to go out to the state of Minnesota today and give you an example. So today, let's spend a few minutes, let's connect the dots for you, and let's talk about the depths that government will go to keep you disarmed. Okay, here's what we're talking about. We're talking about the case of Worth v. Jacobson. What the heck is the case of Worth v. Jacobson? That is a challenge to Minnesota statute section 624-714. What the heck is that, you say? Well, that is a statute that prohibits individuals from, during the age of 18, 19, and 20, those 3 years of purgatory, from being able to get licensed to carry a firearm in the state of Minnesota, okay? So I want you to think about this, okay? You're age 18, you've already been driving for 2 years, you can get legally married, you can go get your own tattoo if you want. You can join the United States military, serve your country, and be killed in combat. But the state of Minnesota says, you know, you're just not quite the kind of person we want carrying a firearm yet. Now, is there a historical analog to support this? Absolutely not. Of course there isn't. No. In fact, if we go back and we look at colonial times, we look at revolutionary times, we look around the time that we adopted our Constitution and the Second Amendment, we even go all the way into our time machine and go just a little bit forward to the time that we adopted the 14th Amendment. No, young people being able to arm themselves was very, very acceptable in the United States at that time. So if you happen to be, let's say the Solicitor General for the state of Minnesota, and you're sitting in front of, the 8th Circuit Court of Appeals on a constitutional challenge to this law, and you realize, man, we have absolutely no historical analog that we can go to that's going to back it up, we're going to get hosed on that. The only argument you would have left is that the Second Amendment does not cover this kind of activity. But of course, now we're talking about the ability to possess a firearm, which clearly the Second Amendment would protect that kind of activity, right? Well, sort of. But you see, this is what Liz Kramer, the Solicitor General for the state of Minnesota, on behalf of the Minnesota Attorney General, argued before the 8th Circuit today.
Summary judgment should have been granted in the state's favor on the first prong of the Bruin test, the scope of the right, because plaintiffs have the burden of proof on that prong and came forward with no evidence at all that 18 to 20-year-olds have ever been considered part of the people or the political community.
Boy, you used the term ever there. And I remember the 26th Amendment, the fastest amendment passed in the United States, history of the United States, scant 3 months. The Supreme Court has said that amendments amend everything before it several times. What role do you give to the 26th Amendment, which clearly says 18, 21 years old are part of the political community, they're Americans, they're people, they're everything?
Bruin makes pretty clear, Your Honor, that we cannot look at anything, say, past 1900. So if you look at...
Counsel, that doesn't answer my question. My question is simply, what role do you give the 26th Amendment? None? Your answer is none.
My answer is none under the guidance of Bruin. So Bruin says to
Okay, now I've got to ask you the follow-up. You know what it is. That shocks me. That the 26th Amendment had no consequence. A huge amendment passed in record time, you heard my point. But you think it doesn't affect anything before it?
Not with respect to the Second Amendment.
Okay, did you get that? Miss Kramer, the Solicitor General for the state of Minnesota. Let me say that. That is the chief litigator for the state of Minnesota. One would assume would have a fundamental understanding of constitutional principles and constitutional amendments. Argued with a straight face to the Eighth Circuit that people who are 18, 19, and 20 years old are not contemplated by the people as announced in the Second Amendment. That is, the constitutional protections to the people do not include 18, 19, and 20-year-olds. A very bold and brash interpretation, to say the least, but also Liz Kramer, Solicitor General for the state of Minnesota, on behalf of the Minnesota Attorney General's office. Yeah, there's this little thing called the 26th Amendment. What does that read? It reads as follows. The right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state on account of age. The Congress shall have power to enforce this article by appropriate legislation. Now, the justice who was questioning Solicitor General Liz Kramer pointed out that, hey, wasn't the 26th Amendment like the fastest one that was ever ratified? The answer is true. Now, the discussions really began back in the early 1960s. However, they really heated up during the Vietnam War. Wonder why. You're 18, 19 years old, you can get drafted, you can be sent to Vietnam, but you don't really have a say in who the president is or who your representative is. You could understand why there was a very good need to allow younger people to vote, especially when we're willing to throw them into combat and get them killed. Okay, so the 26th Amendment was passed in 1971, okay? Now, Solicitor General Liz Kramer of the great state of Minnesota believes that somehow or another Bruin is the only analysis we get to use, that somehow or another the Bruin opinion has actually overruled the 26th Amendment of the United States Constitution. Now, she also says that we really can't look back any past, 1900 is really about as far forward as we could look, which I don't know where she has that number. There's been great debate about what that number is. 1900 is never in the equation. But you want to know the depths that government attorneys will go to in order to keep you disarmed, the lawful and responsible gun-owning American? Well, it's this. It's people like Solicitor General Liz Kramer of the great state of Minnesota, who believes that 18, 19, and 20-year-old individuals are not covered by the language "the people" in the Second Amendment, despite the fact that since 1971 they have been through the 26th Amendment. Listen, we'll go ahead and link up everything down below so that you can geek out on it for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is down there in the description box as well. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.